British national Roger Wallis, accused of the attempting kidnapping of an 8-year-old Belmopan student, returned to the central prison in Hattieville after a bail application made on his behalf by attorney Earl Hamilton was struck down by Supreme Court Judge Justice Adolph Lucas. The 63-year-old owner of Area 52 Entertainment Company was paraded from the cell block to the courtroom just before 2 p.m. today, where objections were heard. Crown Counsel Portia Stain Ferguson opposed bail on the grounds that the visitor's permit, renewed monthly by Wallis, expires today and that the crime carries a sentence of no less than 10 years behind bars. Among his submissions, however, Hamilton presented that his client has substantial ties to Belize and due to his medical condition should be granted bail since Wallis is innocent until proven guilty.
The presumption of innocence must always prevail. You are innocent until proven guilty. The other submission that I have made was that the petitioner has substantial ties in Belize. What is the risk that the petitioner is going to abscond and not show up for his court date? Petitioner health issues. Petitioner is diabetic. He has a kidney problem. The presumption of innocence is not only for Belizeans, it's for everybody, anyone who is brought before the courts of Belize. As it stands, Mr. Roger Wallis is innocent until proven guilty. I can understand that the public might have their own perception, their own views, but the law is the law in Belize. You are innocent until proven guilty.
Justice Adolph Lucas denied bail on several grounds: that Wallis is not a Belizean, the alleged offenses against an 8-year-old minor and occurred in front of his siblings. His third reason was that due to the seriousness of the charge, there is an incentive for Wallis to abscond and not attend court.
We disagree with the judge, obviously, but we respect the judge's decision. That's the judge's decision. The judge was of the view that the petitioner, Mr. Wallis, is not a Belizean. He's a British national. And the offense of kidnapping is a serious offense. And he was of the view that bail should not be granted. Clearly, as I said, we are disappointed, we disagree, but we respect the judge's decision.
As was disclosed in court today, the incident occurred on September 24th between 11:30 a.m. and 12:30 p.m. as 3 siblings ages 8, 12, and 14 were walking on a street in Belmopan when they were allegedly approached by Wallis, who offered them a ride. The children said no, but Wallis allegedly circled around and grabbed the 8-year-old in an attempt to pull him into the white van he was driving. The older siblings then fought him off and escaped. In a caution statement by Wallis, he admits to speaking to 3 children on the same day. However, he says he was only asking for directions.
Caution statements that was obtained by the police, they are irregular. They were not obtained properly, and they were not in compliance of the Evidence Act. I won't go into why it was irregular, but suffice to say today that the caution statement is irregular. I will go further. An identification parade was held. An identification parade was held. It was held about 5 o'clock, I believe on the 28th of September. Mr. Roger Wallis' face was all over social media, 4 o'clock in the evening. The identification parade was irregular as well. His attorney was not present. It did not comply with Section 5 of, I can't remember the exact number of the statutory instrument, but there are guidelines. They did not comply with certain sections of the guidelines to have a true and proper identification parade.
But all is not lost, says Attorney Hamilton, because a preliminary inquiry was ordered by Justice Lucas on or before December 17th, and Wallis must be further arraigned in the Belmopan Supreme Court on April 3rd, 2019. A reapplication for bail can be made if the Crown fails to meet the timeline.
Even though the judge have denied bail at first instance, the judge is still mindful of the petitioner's presumption of innocence that is afforded to him by the Constitution. I am of the view now that he is entitled to bail. Clearly, the judge has a different position, and we respect that position. So I believe on the next occasion, if those conditions are not complied with, I believe the defendant should be afforded bail.
Duane Moody for News 5.